Hello, it's Tim McEleenan here. Welcome to the second edition of the Conservative Income Investor Podcast. And today we're going to talk about settling an estate. If you agree to be someone's executor and you're in charge of distributing their estate when they die, what's the lay of the land? What step by step is it that you just agreed to do? For today's podcast, I broke down into 13 steps what it is that you need to do as the executor of the estate. Step 1, oversee the funeral arrangements. Now, in most states, the rule is the person's spouse gets to determine expenses. If you're a spouse who's also an executor, no big deal here. You determine the expenses. If the spouse is alive and you're the executor, your role is only oversight. The spouse gets to decide the funeral arrangements, but you get to oversee it to make sure that it's not unreasonable. Now, in the eyes of the law, unreasonable is a very high hurdle to meet. So if someone has a $20,000, $25,000 funeral and the average in the area is $12,000 or $13,000, that's not going to count as unreasonable. That's going to be the high end of reasonable. For a funeral to be unreasonable, we're talking just something that you've never seen before, and they're just spending a lot of money, especially compared to the assets of the estate. I mean, we're talking taking Abraham Lincoln, by horse from Washington, D.C. to Springfield. That's the kind of, it has to be something way out there. Funeral expenses are almost never, ever contested, but you do have an oversight role, and if they are higher than usual, that is something that you would be responsible for. Also, if there's no surviving spouse, then you also have the oversight role. If there's close family like kids or a sibling, you may defer and let them decide, but you still have an oversight role to make sure that it's not unreasonable. Again, this is a very high hurdle, and spending more. Don't use a layman's understanding of the term and think, oh gee, this person's spending a couple $1,000s more than usual. Is this unreasonable? No, you don't have to worry about that. It has to get much higher than almost beyond reason, like a $40,000, $50,000, $60,000 funeral for someone with $200,000 in assets. It would have to be something that's just eating up the estate, or it's just a crazy expenditure. So that's the first thing you have to do. Once the funeral's over, you move to step 2, which is you find the will. You find the will, and then at that point you sort of get a sword and the shield out, and you sort of go into a defensive mode. Your job is to identify the assets of the deceased. You have to tally up the expenses that have been accruing in general and as a result of the death, and then you also have a job to protect against both theft and conversion. So take the keys to the car. If there's no spouse, get the house on lockdown. Make sure that there's no chance that things will get stolen on your watch. Now, the step 3 is you figure out what are probate assets and what are non-probate assets. This may surprise you, but there's only going to be a relatively small amount of assets, most likely, that you're going to be overseeing. Probate assets are those that the decedents either held alone or that they held as a tenant in common. So most likely a lot of their wealth won't even have to go through you. It won't go through probate. So if there's a spouse with joint tenancy property or tenancy by the entirety and there's a surviving spouse, that spouse is going to get it. Doesn't go through probate. Are there any kinds of trust, lifetime trust, living trust? That's not going to go through probate. Are there any life insurance proceeds? That's not going to go through probate. 401k assets, IRAs, pensions, none of that goes through probate. Payable on death accounts, those don't go through probate. So it's entirely possible that there may be no probate assets until the surviving spouse dies. And it's also true that a lot of times in wealthier families, they put almost the entirety of their assets in trust. So you're looking for things that the decedent held alone or as a tenant in common. That's what's going to go to probate, and that's what's going to be your responsibility to administer. So those are the assets you're going to be focused on. Now let's move on to the next step, step 4. This is when you're opening the estate for probate. So you petition to the probate court, and you fill out a standard form. You go to the local courthouse. There's usually going to be a clerk there who will work with you. They're very nice. They're God's gifts to the civilization. They're the sort of the grease that sort of lets everything work. And you're going to fill out some forms, and it's to admit the will into probate. If there is no will, and you're just say the person who died orally told you to be that they wanted you to be the executor, then you're going to fill out something called a petition for administration and appointment of representative. But that too is on a standard form. And so at that point, you've initiated the court, and you're sort of on the grid. And the next thing the next step is called proving the will. And so basically, if you submit a will, the next thing you have to figure out is this thing valid? Is this thing credible? Is this actually, what the person created? Does it reflect their intent? So if there's any contest over it, you're going to have testimony by witnesses. They'll come in. They might file an affidavit. If someone wants to make a challenge, this is a time, and the court will listen to this testimony and decide whether the will was valid. If there's not really a contest and everyone's like, yeah, that's the guy's will, yeah, these are his heirs, these are the people who are going to get his stuff, then the process will be very informal. If it's challenged and we have a will contest, then things will get far more formal. But otherwise, the will's proved, and you move on. Now, assuming the will is valid, the court will sign something called admission of the will to probate, followed by a letters testamentary to the executor. The letters testamentary is what grants you as the executor the authority to start doing stuff. You get to pay bills. You get to interact with creditors. It's going to give you the eventual authority to distribute the assets. So this is really, once the judge issues the letters testamentary, this is really when your power kicks in. You had power before, but it was more of, before the letters testamentary, you were more of a watchdog preventing bad things from happening. You didn't want anything unreasonable to happen during the funeral. You didn't want anything to get stolen from the estate before it entered the court's hands. But once you get the letters testamentary from the judge, that's when you finally get to start doing stuff. That's when your formal authority kicks in. Now the next step, and this is something that varies state by state. Probate, this is always a state law process, and so you should keep in mind that I'm giving you general rules, and your state is going to be governed by statute, which could be very different from what I say. And so you need to follow what the statute says, because that's going to be the governing law, and I'm just telling you what the general lay of the land is. And here's one of the things that does vary state by state. Some states you need to get a bond that guarantees performance. Most wills in states will waive the bond requirement, so there's no need to guarantee performance, but that could be the next step. It's unusual, but it does happen, and so that's why I mentioned it as the next step. And now, the step after that is this going to be a formal or an informal administration of assets? And of course, this depends on is it we know what's going on and it's just a matter of distributing it, or are there actually things that are contested? So if it's a formal process, then that means you're going to have court supervision almost every step of the way, because things are contested, and so it makes sense. You want the judge to sort of be involved in the process. If it's an informal process, this person has 2 kids, the wife's dead, the kids get each thing, get half the assets. Then what happens there is the executor gets to do everything until it's over, and then he says, "Hey judge, here's what I did. It's the estate, it's been completed, it's been perfected. Now sign off here, and we're done." And there's actually something called universal succession, which has been a new trend when estates are very clear and easy to administer. And what universal succession is, something that people can include in their wills when it's very clear, someone doesn't have a surviving spouse and say they have 1 kid who's going to get everything. That person in the universal succession plan, they have an automatic grant of title, so everything goes to them right away, and they have an obligation to pay creditors. So basically it's everything's yours, and then you pay the bills, and if you don't pay the bills, then they haul you to court to pay it, but otherwise everything's settled. And that's a very quick way to get money, and assuming that you're someone who if someone has dies with almost no debt, that's something that you might want to look into for your own estate planning. So if things are informal, that's it. It's over. It's you administer it, and then you let the judge when it's done. Now, if things are contested, then your job gets a little bit harder, and it's the formal process. That's why this is a 13-step guide. It would be about a 5 or 6-step guide if I only did estates that weren't contested. So if things are formal, then what you do is your next step is going to be filing an inventory sheet for the court. And so what you do is you basically list all of the person's assets. You say, okay, this is what they have, this is what they owe, and you itemize that. If they have a 2-year-old car, maybe you can use Kelley Blue Book value. If there's a second house that they owned in the state, then an appraisal may be required. So your point is to figure out what do they own and what are the values on that, and you file that with the court. And then the next step is you collect all assets, and this is when those letters testamentary that granted you authority, they start coming in handy. If it's a formal process, meaning a will it's being contested, there's a matter of controversy, and you have court supervision, what you're going to do now is establish a new bank account. You go to the bank, you show them the letters testamentary, and you say, "I'm the executor for the estate of Tim McAleenan," and then you open up that new bank account. And so now what you do is you transfer all the property to that account. If there's a $40,000 car sitting in the driveway, you sell it for $40,000. Who do they make the check out to? They make it out to the estate of Tim McAleenan. You take that check, you put it in the bank account for the estate of Tim McAleenan's bank account. If you pay debts, if you're consulting an attorney throughout this process, which is something you should probably be doing if it's a formal administration, then your attorney fees come out of this account. If there's other expenses, if TV bills, internet bills, utility bills still coming in from the house, you pay it from this account. And so now the next thing you do is you enter what's called the sort of general holding period. This is when the assets get assembled. This is the period when you're selling the car, anything that needs to be turned into a liquid asset. It's the period when you're doing that, and it's also the period where if there's creditors, they get to file claims. So if someone says, "I just painted the house and he hasn't paid this $3,000 bill," you look it up and you say, okay, yeah, the house did get paid. This did happen. You write the person a check. On the other hand, you also have the power to determine that something isn't a valid bill. So if a creditor comes, someone's is trying to be a little opportunistic and says, "Oh yeah, I was cutting your grass this summer, and it's a shame he died. Here's a $800 bill for all the grass cutting," and you're like, "Well, wait a second. I know that the dead person, cut their grass all the time. This isn't right. He didn't have someone cut his grass." Then you say, "No, that's not a valid credit. I'm not going to pay it." You take it up with the judge. You petition the court for payment. And so it's not your problem anymore. The judge can sort it out. And so if someone was trying to take advantage of you, they're probably going to go away. They're not going to do anything to have themselves tied up in the legal fashion. So The other thing you have to do during this holding period, and it's the next step, is you gauge the tax liability. Is there going to be estate taxes, inheritance taxes, death taxes? If taxes have, a lot of this depends on the size of the estate that's under your control. If yes, then your next job is to file the returns and pay the taxes. If there's anything left over that hasn't been sold yet. So let's say that there was a car that you needed to sell that was held in the person's name alone, and you thought it was worth $40,000, and you got a tax bill coming up, and no one's offered $40,000 yet. Basically, you sell it for what you can get that day. You say, okay, Saturday, there's going to be a bidding process. Someone pays $25,000. Okay, you take that and you sell it for that amount. You will not get in trouble for selling something that has been on the market but got sold in order to pay a tax bill. You're discharging your obligations faithfully, even if what you get at that time is less than the full market value. The next thing you need to do is see if there's any family allowance request. So, for instance, if this would be very unusual, but if there was a situation where someone had like a lot of their assets in their name, and there was like a surviving spouse, or there was like, say, one kid, and they actually needed the money to, let's say a father was in the habit of giving his son $4,000 a month to live on, and that had just been an established practice since time immemorial, and that son needs the money, he can make a family allowance request. Now, when you get one of these, the smartest thing you should do is just take that back to the judge and say, what do I do here? Because that is something that has very specific state law, like that's going to be governed by statutes, how you should respond to that. So if you get a family allowance request, you go straight to the judge and say, how do I handle this? Because that's not something you can just make up on your own, but you should know that when someone's asking for a family allowance request, it may not it's not necessarily fishy. So don't be quick to say, oh, this is invalid. Just say, okay, well, let's talk to the judge about this, and that's usually the best way to handle it. And if the holding period ends and things get worked out with the creditors, and you sold up and liquidated the assets, then you tell the judge in a formal administration process, say, okay, I'm ready to approve. I'm going to write a $30,000 check to son 1, a $30,000 check to daughter 2. I'm going to pay the $2,500 in legal fees I had to incur in administering this, and then after that, I am going to close the bank account for this executor for the estate of Tim McLean I had to create. And the judge will say, yeah, that's exactly what we agreed on, and he'll sign off on that. If you don't get it exactly right, he'll tell you what to do, and at that point, you would cut the checks, and then at that point, the estate is closed. So, again, I want to stress that this is something that varies state by state and is governed by statute. And so this is just a very topical lay of the land overview. And the states can and do things differently from this. So you want to go to you can look up your state's laws. Usually Cornell.edu, Cornell, like the Ivy League school. They have a website that tells you all of the statutes for a given state, and it's incredibly useful for figuring out what the laws are for probate. So as you can see here, that if you agree to be the executor for someone's estate, it's not like, oh, will you be so-and-so's godfather or something like that. No, it's not just an honorary thing. It can be an easy thing to do if there's minimal debt involved in who's going to be entitled to the remains of the estate is clear. But it can't, if there's anything contested, it can be a real headache, and it can get very formal in a hurry. And last thing I want to say is, since this is close to getting into legal territory, is the necessary disclaimer. This podcast, which I believe may be of interest to readers, is for general information and entertainment purposes only. It only reflects my best understanding of the topic at hand and should not in any way be relied upon as legal or investment advice. Thank you for listening. Tim McLean.